the things I think that's really important to understand is that and you have to remember, I was trained as a journalist, and journalists are particularly tenacious about First Amendment rights, and journalists sometimes go to jail over those First Amendment rights. But no right is absolute. All rights have to be balanced against other rights, and sometimes our constitutional rights conflict. But there always has to be a balance struck. And with respect to First Amendment rights in political campaigns, one of the balancing acts that our society has to engage in, and then ultimately the courts have to decide, is the balance between your ability to spend unlimited sums of money to express yourself and the interest in protecting our system of government against corruption or even the appearance of corruption, which can have a horribly corrosive effect on public confidence in our government, or in our courts for that matter. And that's there is a long history of U.S. Supreme Court cases that deal with that very balancing act. And what the courts have said is that you can regulate and even limit campaign contributions, for example, in the interest of preventing corruption or even the appearance of corruption. And you can also require disclosure. Even if some would argue that that would have a chilling effect, disclosing that you're spending the money might have a chilling effect on somebody spending their personal fortune or some corporate treasury, that you can require disclosure in the interest of transparency and openness in government, again, to protect against corruption or the appearance of corruption. I mentioned that there's this electioneering disclosure bill that is before our legislature now. Well, the U.S. Supreme Court has had two recent opportunities to strike such disclosure requirements down as unconstitutional, and both times the court has declined to do so, saying that you can require disclosure and you can regulate this activity in the interest of preventing corruption. And so this very dilemma about how you protect First Amendment rights is played out in court. The first case was McConnell versus FEC, which was the first direct challenge to the McCain-Feingold law. And the U.S. Supreme Court upheld the law and said the disclosure is fine, it's not a First Amendment violation. Second case was Wisconsin Right to Life versus FEC, and the court ruled again that you can require disclosure, but you need to distinguish between the functional equivalent of election campaigning and grassroots lobby. You have to distinguish between somebody trying to influence government decisions and somebody trying to influence an election. And if it's trying to influence voters and influence an election, that can be regulated, full disclosure can be required, that's constitutional. And that's within, that doesn't violate First Amendment protections. So I think it's really important to understand that there's always this balancing act that has to be struck, and that anybody who tells you that all campaign finance reform law is on shaky ground constitutionally because it violates the First Amendment has not faithfully looked at the long history of U.S. Supreme Court rulings. You can regulate campaign contributions, you can require disclosure, all of that's constitutional. Sometimes you have to be really careful about how you do it, but you can do this. It is constitutional. And by the way, the rules that are now before the legislature on electioneering disclosure actually use the words of Justice Roberts, who wrote the majority opinion in the Right to Life case. He uses his own test that he spelled out about what can be regulated and what can't. I think it was made as constitutionally bulletproof as you could possibly make this legislation.